Both parties are present here. Each of you, of course, will have 15 minutes to present your arguments. Attorney will, you can reserve up to 5 minutes for rebuttal. And let me know if you're going to reserve time and how much, and I'll try to keep track of that for you. The arguments are recorded, so we ask that you keep your voice up. And victims or children will use initials. We've read the briefs and we're prepared to proceed if you are. Oh, and the case is State of Ohio versus Benjamin. I'm going to do it. Klafczynski. Was that pronounced correctly?
Klafczynski.
Okay.
Close enough.
Thank you. It's case number 18CA0084. All right, Attorney Immel.
Good morning, Your Honor. May it please the Court. My name is Christopher Immel, and I'm here representing Benjamin Klafczynski, the appellant in this matter. I would ask the Court to reserve 3 minutes for rebuttal.
And I'll do that for you. Thank you.
Thank you. In our briefs, the Court is aware we have raised several different issues on appeal. However, today I am going to touch on 3 of those issues that we see as being most important and due to the time constraints. The first is, was the trial court's denial and the state's denial of Mr. Klafczynski to examine the victim's cell phone in this matter for potential exculpatory evidence a Brady violation. In this matter, the state failed to turn over a copy of the victim's phone in discovery, or at least maintain a full copy of that phone in evidence during the investigation and subsequent trial of this matter. The trial court denied Mr. Klafczynski's motion for an independent expert to evaluate and review that phone for any exculpatory evidence. Under Brady, there are 3 factors that the court must consider to determine whether or not a Brady violation occurred. The first was, is there any favorable information or evidence to the individual, either exculpatory or impeaching? Second, evidence must be suppressed either willfully or inadvertently, meaning the state can do it intentionally or unintentionally. And lastly, prejudice must ensue based on the suppression of evidence. At trial, officers testified that an extraction of the victim's phone was performed. This phone, as the basis of the allegation, was that there was communication and messages and pictures sent back and forth between Mr. Klafczynski and the victim. So clearly there was communication and data on this phone that relates to the tampering with evidence charge and correspondence between the 2 individuals. The state only took photographs of their interpretation and pulled only relevant information off of the phone and then released the phone back to the victim. They did not take a full copy or clone of that phone. The state then denied that any information of the phone would be utilized as evidence at the trial. It does appear in the transcript. The state did, however, introduce at trial, although it was ultimately not admitted as an exhibit, a PDF of the extraction of the phone. Prejudice did occur to Mr. Klafczynski in the simple fact that they should have maintained a copy of the phone, as witnesses testified of the text communications and photographs that were sent in the Snapchat app, and that what was displayed to the jury and ultimately admitted was only a partial and not complete showing of the messages. The victim in this matter who testified about those messages specifically stated, I only saved a certain number of those messages. I didn't save all of the relating communication in that conversation. And by reading those exhibits and those messages, it is clear that there is a gap in the communication in the conversation, and there's no evidence to show what those communications were.
Counsel?
Yes.
You're on a roll. I hate to interrupt you, but can I go back to the PDF?
Yes.
I understand from the briefs that it probably wasn't even opened in front of the jury, but what was it? The PDF? It wasn't the PDF of her contents of her phone?
It was data showing what was on the phone, whether there were logs to the applications, logs to the text messages.
And was the PDF made available
only the small portion that the state had. They did not have the full copy of the phone. They only had a small, limited copy of the phone.
He was only convicted of tampering.
That is
Am I right
correct.
on that?
That is correct.
And the tampering would have been removing information from his own phone.
From his own phone. The evidence that the logs of her phone would have shown whether or not messages were sent, certain pictures potentially were sent, which would have shown that something was sent. We know, okay, and then all of a sudden it's not on his phone. It could have been incriminating, but it also could have been exculpatory to the fact that there's nothing there, there's nothing on his phone. He didn't delete, he didn't remove, he didn't destroy anything. The state then fails to prove the tampering with evidence charge, or at least submits to the jury that there is a question as to whether or not this supposed evidence was even there to begin with.
Well, there's no disagreement that he deleted the Snapchat app.
That's correct.
So wouldn't that be enough in and of itself?
I'm going to get to that, Your Honor.
Okay,
We can address that now. Snapchat, and there was testimony from the victim in this as a lay witness about her use of Snapchat, and that Snapchat, when used, pictures, messages, when sent and then viewed by the receiving party, are deleted. The nature of the app itself deletes the information once it's viewed, unless the receiving individual takes what's known as a screenshot of that image or conversation. If by in fact that the app itself is self-deleting, there's going to be nothing there when the state goes to look at it saying, yes, this was sent, or what exactly was sent.
Right.
So even the fact that he removes the app from his phone is not tampering with evidence, because the app has already deleted everything on its own by the nature of the application
What if he
itself.
screenshot it and then deleted it? Is that a different?
That would be a different question, because then there would actually be, my understanding is there would actually be logs in the phone then that show this information was actually stored on the phone itself and not within the Snapchat.
What evidence was there that was there any evidence that he did do a screenshot of the picture of the young lady?
There was testimony from the victim that she was notified that there was screenshots taken.
Was that the extent of it?
That was the extent of it.
I guess I was getting at the fact, and I understand, because anybody that's raised teenagers knows about Snapchat, I understand, but I guess my thing is that I was thinking, when the old boyfriend, the former boyfriend I should say, confronts him, he claims, I didn't even have Snapchat.
He was confronted on December 5th was the testimony. Based on the extraction from Mr. Klafczynski's phone, the app was deleted on December 4th. So at the time of this confrontation, that statement by Mr. Klafczynski is true. He did not have the Snapchat app.
But I guess what I'm still, and obviously this is something we'll have to look at, but I guess what I'm still not completely sure of is he knew that these charges were likely to be filed, or that there was going to be an investigation at that point, right? At December 4th?
I would disagree, Your Honor.
Okay.
And I would disagree based on the fact the Ohio Revised Code sets forth in 3319.311 that the State Board of Education or the Superintendent of Public Instruction on behalf of the board are the ones who conduct any investigation. So the fact that that statute specifically states the State Board of Education and then goes on to include, or the superintendent, by reading that statute, since we were discussing the State Board of Education and not a local Board of Education, the only people who can make that official investigation and proceeding is the State Board of Education with the state superintendent. The statute then goes on to indicate that referrals should be made to the Ohio Attorney General's office for that investigation. This can only occur after an individual individuals getting written notice of this. I would submit to this court that when Mr. Klafczynski has a discussion with the principal and then is notified by the superintendent of the Wadsworth School District that it is not an official criminal investigation, it is a employment contract issue, because his employment with the school district indicates that he should not have that outside communication with students. So then it becomes a civil contract employment issue and not a criminal issue. And therefore, he's not on notice or has no reason to believe that an official investigation or proceeding is likely to occur or has occurred.
Well, I'm sorry. I was just gonna say though, but they're both mandatory reporters. The Board of Education, the principal, all of them are mandatory reporters.
They are, yes.
So he would have to know as a teacher himself that it's eventually gonna get to the police.
Only if he has any inappropriate contact. If he doesn't have any inappropriate contact, there's no mandatory reporting. There is no issue. So he is under no obligation to do a report, nor is anybody else.
I'm sorry, Judge Kelly.
I guess where I was getting kind of baffled, and you're probably going to get into this, was the whole concentration about whether the school board is the right authority or authority that meets the statute. I guess my thought was, if, for the sake of argument, we take the student's word as being the case, I mean, there's nothing about the statutes in terms of investigating teachers and what they need, the AG, that doesn't assert police power. So I guess I'm not sure how everything got concentrated on that issue in the trial.
Yeah, I believe it gets there based on the fact that the state relies on that investigation, that conversation with the principal, the conversation with the superintendent that places Mr. Klafczynski on paid administrative leave as a way of notifying him there's an official proceeding going on. You destroy any evidence at this point, now you can be charged with tampering with evidence. Since the state is relying on that fact as its official proceeding, if it's not under the law as an official proceeding, the state fails to meet and prove an essential element of the tampering with evidence charge.
But does an official proceeding have to go on, or?
Go on or likely to incur.
Was it a police investigation likely to occur if you took her word as she states it?
You can answer this. You're at 2 minutes and 58 seconds. Just
Thank you. Yes, yes, you take her word for it, but again, I would step back to say that it's an employment issue at that point. The conversation is with his employer. It is not with the police. There's been no notification exactly what has occurred or what the allegation is. And I would just point the court to Revised Code 2921.01D, which defines the official proceeding. And the reason the trial court made the jury instruction to include 3319.31 and 3319.311 is because the state of Ohio requested it and got it over defense's objection, because the state was indicating that without those additional code sections, the jury would be confused and the state would be prejudiced by it, which goes right to the fact that the state is relying on this proceeding and this questioning as its official proceeding to meet an essential element of the tampering with evidence charge. And with that, I would reserve the balance of my time.
I'm going to give you 2 minutes and 45 seconds for rebuttal.
Thank you.
All right, 15 minutes, guys.
Good morning, Your Honors. May it please the Court. I'm Vince Felucci with the Medina County Prosecutor's Office for the appellee of the state of Ohio. I will start with the sufficiency and the manifest weight of the tampering charge. The evidence showed beyond a reasonable doubt that Klafczynski tampered with evidence in two different ways. He deleted the Snapchat application from his phone, and he deleted nude photographs of the minor victim from his phone. Klafczynski talks about the idea that he couldn't have deleted anything from his phone because Snapchat automatically deletes messages and photographs. As it was discussed, though, the victim testified, and Klafczynski acknowledged in his brief even, that Snapchat messages and photographs can be saved on a phone by screenshot. That's exactly what happened in this case. That's what Mr. Klafczynski did. That's what the victim testified to. She testified that Snapchat, in fact, did notify her that Klafczynski screenshot some of the nude photographs that she sent him. So he had it
Would that
on
have been on her phone?
I'm sorry.
Would the fact that her picture was screenshotted, would that have been evidence that would have shown up on her phone? That may either be useful or not useful for the defendant?
I don't think so. The fact is, it does, and I don't think it's in the record either way on that, whether it would still be there months later or something to that effect.
I mean, I know she testified that she received notice that her picture was screenshotted. There's nothing in the record that would indicate whether or not evidence of that would have been contained on her phone.
No, I don't believe, so I want to say yes, but at the same time, I don't believe there was any evidence to that effect introduced at trial, and I don't believe that's in the record either way as to whether that was still on her phone at the time. I know they went through in extensive detail all of the messages between the two and the photographs that she sent, but I don't think that particular point is in the record. But there was testimony, as I said, that the photographs were not, in fact, automatically deleted by Snapchat. They were screenshot and saved, therefore, by Mr. Klafczynski. The testimony of Patrolman Cooper, who did the extraction of Klafczynski's phone, was compelling with some important technical information. He testified that a database usage file, as he called it, showed that Snapchat had been used on Mr. Klafczynski's phone, but the actual application was no longer on Mr. Klafczynski's phone. He additionally found that JPEG photographs on the phone had 0 kilobytes, which he testified means that there was no data to be found. But it showed sort of like a relic that a photograph had been there. He testified, as I said, that there have been photographs there which were not there anymore now at the time of this extraction, that showing that something had been deleted. Patrolman Cooper found that the last log entry for Snapchat on Klafczynski's phone was at 7:29 p.m. on December 4th, 2016, which I think was mentioned. Now that first week of December of 2016 was highly significant in this case, because that's when the victim first starts telling her friends and then ultimately telling the school about what Mr. Klafczynski had been doing. The victim's friend, Jack, testified that the victim actually had reached out to him and told him about Klafczynski's actions before December 4th, 2016. Then, he said, for a few days after that, Jack said he didn't answer or respond to any of Klafczynski's calls or texts. And that would have been unusual around that time because of their previous close relationship. He was he's his golf coach and his teacher, and they were also close outside of school. Now, I would submit that it's very likely that that fact alone alerted Mr. Klafczynski that his secret was out, that official investigation was about to come down, likely to occur, maybe even already occurring. Jack actually confronts Klafczynski the next day, this December 5th, 2016, at which time, as was mentioned, Klafczynski falsely told Jack that he never had Snapchat on his phone. He even offered to show Jack his phone. He made a big deal out of that, knowing that he had already deleted the app sometime between 7:29 p.m. the night before and that meeting in the late afternoon of December 5th. And it all becomes even more compelling when you consider the victim and Klafczynski's phone conversation. That, I think, conveniently wasn't brought up by the defense. There was a phone conversation later on December 5th, on that day, after Jack confronts Mr. Klafczynski. During that conversation, Klafczynski actually asked the victim to lie for him about what had been going on, lie about the messages, lie about the new photographs. He said he told Jack that he never had the Snapchat app. He wanted her to back him up on that lie. In that conversation, Klafczynski admitted to the victim that he had deleted Snapchat off of his phone. So he admits that to her. And this wasn't the first time he talked about deleting things from his phone with the victim. On a prior occasion, Klafczynski had sent the victim a Snapchat message saying, quote, "deleting this, LOL." And he also stated that if he were to delete the victim as a friend, that her messages would not show up on his phone. So this is something he thought about long before this, but certainly started thinking about on the week of the first week of December of that year. But there's actually more than that. After Klafczynski was placed on leave, and that happened after he met with the school on December 5th as well. He's placed on leave. The principal then went to Klafczynski's classroom to pick up his personal belongings. And what he found there was very interesting. He discovered a sticky note in Klafczynski's desk drawer, on which Klafczynski had basically written out a script for himself outlining how he thought he was going to get away with this. And what he wrote was, quote, "Number one, coming over, question mark." And that refers to many times when Klafczynski was attempting to get the victim to come over to his house and have a face-to-face conversation with him, at which he likely was going to, in person, try to convince her to lie for him. He repeatedly tried to get her to come over and discuss this. Number three, he talks about moving forward. I'll skip number two, but in number three, moving forward, he writes the words moving forward. And he says those words a lot in the messages to the victim, trying to move forward, doesn't want her to dwell on this too much or tell anybody about it. But number two is really the most compelling, where he writes, "Snapchat delete last pics." So he actually writes down, as part of his plan, he's going to delete Snapchat, he's going to delete photographs from his phone, which is exactly what he did. So that's obviously even more compelling evidence that Klafczynski deleted the Snapchat application, deleted the photographs of the victim after he knew his secret was out, or at least was going to come out very soon. So with all that, I would submit the jury easily could have inferred that Klafczynski deleted Snapchat, deleted the incriminating photographs of the victim sometime after 7:29 p.m. on December 4th, but before Jack confronted him in the late afternoon of December 5th. So at that time, he's confident enough to say, "Here's my phone, Snapchat's not on there anymore." In terms of the extraction of the phone, of the victim's phone, I don't believe there's any evidence in the record that anything less than a full extraction was done on the victim's phone. I don't think that's really clear in the record, but there was very limited testimony by Patrolman Cooper about the actual extraction of the victim's phone. That was not a focus of the state's case. That was really not the state's case, at least in terms of the tampering, which is what we're dealing with here. He was acquitted of the other charges. We're only talking about tampering. So the state of Ohio was never talking about from day one, and that this is all over the record, the prosecutor talking about, we are not talking about him tampering with her phone. We're talking about him tampering with his phone. Wasn't relevant. Was never admitted as an exhibit. The extraction was never admitted as an exhibit at trial. It was only briefly mentioned at trial in very broad strokes.
So his defense was none of this ever occurred. So, right? He's saying none of this is going to be on none of this is on my phone because it didn't happen. And I could show that by examining her phone, that none of these messages came, none of these photos came, am I right?
Well, he knew it wasn't going to be on his phone because he deleted everything. He tampered with evidence. But in terms of her phone, there was extensive testimony about that from her and the messages directly. Now, in terms of the technical extraction, the jury never saw that. That wasn't something that was focused on. There's no evidence that anything there was going to be favorable to him, or that he was prejudiced in any way by this. In fact, what he wanted to do, he wanted his independent expert to analyze this phone, and there were a couple hearings on that actually. So there's quite a bit in the record on that. And actually, when the prosecutor cross-examined his expert and asked him, so could you show that there had never been photographs, there had never been nude photographs on his phone? And he said, no, I can't prove a negative. That's why they wanted the phone. They wanted to prove that photographs had never been there. And his expert testified under oath, I can't do what they want me to do. Right there, there's no prejudice. There's nothing favorable. There was nothing that was suppressed by the state. The defense received everything the state had in terms of the extraction of the victim's phone. They had that in discovery.
But was it a full extraction?
I believe it was.
I'm hearing from the briefs, it sounds like it was just bits and pieces.
Well, I believe it was. It was the extraction that was done was the full extraction of the phone, and I don't think there's anything in the record that says otherwise, that this was some kind of a piecemeal extraction. There was a detailed PDF file that was created by this.
So it might have been a detailed, full extraction, but a limited report. Is that a possibility?
Well,
I guess that's a bad question. Does the record reflect any bad situation?
I don't think the record reflects whether that technical detail, like was this how long was this report? Was this a summary? Was this lines of code that only an expert could? I don't think it really says, but I think there's nothing that shows that the state of Ohio, did not turn over everything we had in terms of that extraction, and that's the point of Brady. Was did we suppress anything? And we didn't. And you got to show prejudice. So what's the prejudice if your expert is saying I can't prove a negative? I can't prove there were never nude photographs on his phone.
Are you saying on this phone or his phone?
On his phone. I'm sorry, on the victim's phone.
Yes, I was wondering, okay.
Yeah. If, like he's saying, these new photographs never existed, I can't prove that.
So you're saying from that it could never have been exculpatory?
Correct. So,
Council, I am sorry, we're about 20 seconds over time.
okay, I would just ask that this
Your
court.
argument is so intriguing that I.
Thank you. I would just ask that this court affirm the trial court. Thank you very much.
All right, I guess that's only fair because I gave Chris, or I should say Attorney Emmel, some extra time there for his argument too. You'll have 2 minutes and 45 seconds, Attorney Emmel, for your rebuttal.
Thank you, Eric. The state indicates that testimony was the screenshot showed up on the victim's phone. The victim still had Snapchat on her phone. There would have been a log in Snapchat file that a screenshot was taken. There obviously was nothing on Mr. Klafczynski's phone because he did not have the app on his phone. Further, just because there's a JPEG with 0 kilobytes indicates that a photo has been there. There's no way to know what that photo was, when that photo was there. Is that photo 5 years old, 5 seconds old, 2 weeks old? There's also no testimony as to when that sticky note was written and put on in Mr. Klafczynski's desk. Was it placed there on December 5th? Was it put there on December 1st? Was it put there at the beginning of the school year? I submit to this court that the notes on there are Mr. Klafczynski worried about his employment. He knowing that having any outside communication on a mobile device is a violation of his employment. He's worried about his employment, not any criminal proceedings. Officer Cooper testified at trial that there's no way to know when the app was deleted or if any pictures were on the phone that were deleted within the state's allegation when the crime occurred between November 1st of 2016 to December 6th of 2016. There is testimony about her phone, as we've already discussed. There was my understanding from reviewing the record is that the full digital files were not turned over. It was only the reports. We can look at the reports, but we have to have somebody with the technical knowledge to review the actual digital extraction of the phone.
So where in the record would that be?
That would be throughout the record. My understanding in reviewing the record in the hearings that were had regarding the phone and what extractions were taken of the victim's phone was what was turned over in discovery was, here it is, here's what we have. It was not a, say, a flash drive, USB drive, CD or something that has the full digital aspect of it. Based on that, and the state submits that we turned over everything we had. Just because they turned over everything they had, there's a second prong to Brady in the first factor is whether it's either willfully or inadvertently. Just because the state turns over everything they have does not mean that they missed something in their review of that phone if they did not take a full extraction of the phone. Based on all of the issues that occurred, we would submit to the court that this case needs to be reversed and remanded to the trial court. Thank you.
Thank you both for excellent arguments. We'll take the matter under review and issue a decision in due course. Courts will mail you a copy of the decision on the day it's released. You can also see the court's decision on the Supreme Court of Ohio's website, as you both know. Again, thank you both for being here this morning and arguing.